All right, everyone, are we ready to go? You've all made it to the last speaker. Scott Roberts is going to be speaking next, which goes well along with the Rudolph the Red-Nosed Reindeer because he's going to be talking about marijuana in the workplace. Scott is a founding member of the Birmingham insurance defense firm of Burgess Roberts LLC for over 30 years. He has been advising and representing employers, insurance carriers, and third-party administrators in the areas of workers' compensation and general insurance defense. He's been named to the Alabama Super Lawyers publication and is listed in the Bar Register of Preeminent Lawyers and AM Best Recommended Insurance Attorneys. In addition to the Alabama Workers' Comp Association, Scott is also a member of the Alabama Defense Lawyers Association, the Defense Research Institute, and the Alabama Self-Insured Association. So please help me welcome Scott Roberts.
Thank you. Sure I don't fall. Can everybody hear me? Okay. Can everybody hear me? Okay. Good morning to the people here and to the many people that are tuned in online, some of whom may be in the Eastern time zone. Good afternoon. I'm honored that the AWCO asked me to return for a 5th year to talk about developments in legalized marijuana and their potential on work comp claims. Now, I first spoke on this subject in 2017, and at the time, there were 24 states that had some form of legalized marijuana. And after that first year, whenever I have returned to speak, I have always started my presentation by commenting that there had been a lot of changes and a lot of developments since I last spoke, especially regarding state laws legalization of marijuana. And this year is no different. In fact, this year, Alabama became the 37th state to pass a medical marijuana law. I never thought I would see that happen. Now, it's Mississippi recently, their appellate courts overturned their marijuana law. So we are now the 36th state because there is no 37th. But before we start talking about the new law, I just want to talk briefly about what is, we hear marijuana and cannabis and things of that nature. Marijuana and hemp are derivatives of the cannabis plant. Now, cannabidiol or CBD, which we've all heard a lot about especially over the last couple of years, does not include the psychoactive ingredient that marijuana has that makes the user high or lose coordination. Doesn't have the mind-altering effects that marijuana has with THC, which I'll talk about in a second. To qualify as CBD, it must contain less than 0.3% THC. Now, marijuana contains THC, and THC is that ingredient that gets the user high. I want to talk first about how federal law, what they say about cannabis and the legality of cannabis, marijuana, and CBD. Under the 1970 Controlled Substances Act, federal law prohibited cannabis in any form. That means no marijuana, no cannabidiol, which is CBD, nothing whatsoever. And it remained that way until 2018. And in 2018, the federal government, the legislature passed and the president signed the Farm Bill. And what the Farm Bill did, one of the things the Farm Bill did was to legalize industrial hemp. And CBD comes from hemp. So after that law was passed in December of 2018 and signed by the president, it was legal to purchase CBD. And CBD has been marketed as a treatment for conditions such as pain and anxiety, muscle spasms, depression, and things of that nature. Now, even though the federal government legalized CBD, it is not regulated by the FDA. It is still considered a supplement. Marijuana with THC in it is still illegal under federal law. It is defined as a Schedule I drug. And a Schedule I drug is one that is highly likely to be addictive and has no medical value whatsoever. Other drugs that are included in Schedule I along with marijuana are cocaine, heroin, ecstasy, LSD, and things like that. Just to give you some perspective, Schedule II drugs are also likely to be abused, but they do have a medical purpose. And medications included in Schedule II are clonopin and Xanax and opioids and OxyContin and things of that nature. Now, under federal law, the most important reason that marijuana is illegal is due to the Department of Transportation's regulations of people that have safety-sensitive jobs, truck drivers, pilots, train engineers, maintenance personnel, ships captains, and things like that. Under the DOT regulations, any worker that tests positive for marijuana, and it doesn't matter if it's legal or not, depending on the state that they're in, any worker that tests positive for legal marijuana has to immediately be pulled from their safety-sensitive job. And that's even in states that have legalized marijuana. Now, employers that are in states with legalized marijuana, like Alabama, they don't have to test their employees for drugs. But unless those employees come under the coverage of the Department of Transportation. So employers in Alabama that have CDL drivers, that have heavy equipment operators, those people still fall under DOT jurisdiction, even though they're in Alabama, which now has legalized marijuana. So because federal law still makes marijuana illegal, it has caused a lot of issues in states that have legalized marijuana. One of those, I'm going to talk about a few of them, but one of those is marijuana with THC in it cannot be transported to other states. It can't go over state lines because the federal government regulates interstate commerce. There can be no payments for marijuana by patients by check because that uses the federal banking system. And again, because marijuana is illegal under federal law, it can't be used. A company or a retailer that sells marijuana can't put their money in a bank either. Most health insurance carriers will not approve any treatment unless it is FDA approved. And since marijuana is illegal under federal law, the FDA does not regulate it whatsoever. Doctors cannot prescribe marijuana. And the reason is doctors, their ability to prescribe drugs is governed by the DEA. So again, since marijuana is illegal federally, doctors can't prescribe it. And as we'll say in a minute, they can recommend it. That's how they get around that. There has also been a lot of problems on how to bill medical marijuana in states that have legalized marijuana because there is no guidance from the federal government. There's no national drug code. There are no fee schedules or customary uses. And I say there are no fee schedules. One state, New Mexico, which was one of the first to hold that medical marijuana was a reasonable and necessary medical treatment and was thus the employer's responsibility to pay, does have medical marijuana in its fee schedule. But it's the only state, and I can't remember, it's 2 ounces, and I can't remember how much it was. But another complication with federal law making marijuana illegal is Medicare set-asides. Because marijuana is illegal, CMS will not consider the cost of medical marijuana when calculating the value of a Medicare set-aside account. So what, if anything, is the US Congress doing to change these things, to maybe change the status of marijuana under federal law? And there's currently a bill in front of the House of Representatives to lessen or deschedule marijuana and drop it down to a Schedule II drug. And remember, Schedule II might be likely to be abused, but it does have a medical purpose. So let's talk about Alabama's new medical marijuana law. On May 17th of this year, our governor, Kay Ivey, signed the Hall Compassion Act. And what that law did was make medical marijuana legal in Alabama for certain qualifying medical conditions. Now, one thing that is very clear in the Compassion Act is that Alabama is not considering whether to legalize recreational marijuana in this state. I don't think that will ever happen, but the Compassion Act legalizes medical marijuana for treating certain qualified conditions. And the law lists about 16 or 17 conditions that qualify. There are only about 3, I think, that will apply to work comp situations. The first and probably the most important is marijuana treating people with chronic or intractable pain where conventional medicine and opioid therapy has proven ineffective. And the other 2 situations that I think might impact work comp, though, to a lesser degree, are as a treatment for depression and for post-traumatic stress disorder. I think in the early days of medical marijuana being out there and patients getting to use it, I think in the work comps realm, there'll be a lot of pushback from employers and work comp carriers as to whether the doctor truly exhausted all conventional means of medical treatment, including opioid therapy. So what are the legal requirements under Alabama's new law to qualify to get it's called a cannabis card? Well, first, a person has to be a resident of this state. They have to have a certified doctor recommend medical marijuana as a treatment. Again, recommend. A doctor cannot prescribe it. Now they'll be certified in Alabama. Doctors will be eventually, there will be training to make sure they are certified to recommend medical marijuana. And finally, the patient will pay a fee not to exceed $65. Alabama's new law has very specific ways that marijuana can be produced in specific types of products, and it forbids a lot of other products that can't contain marijuana. Now, under Alabama's law, distributing medical marijuana in a capsule or tablet is okay. In a non-sugar-coated gelatinous cube or cuboid, which that sounds like an unappetizing description of gummy bears. It can be in a gel or an oral oil or a cream or other topical preparation. It can be in a transdermal patch. It can be in a nebulizer. It can be a liquid or oil for an inhaler, and it can be a suppository. Now, yeah, that's probably not the most fun one. Although I don't know the gelatinous cube, I want to see what that is first. But Alabama's law also specifically lists items that cannot contain medical marijuana. It cannot be smoked. It cannot be vaped. It cannot be covered in sugar. It cannot be edible, and it cannot be in plant form. Now, the State Cannabis Commission will establish one universal flavor for the gelatinous cubes and cuboids. And they can't have sugar, so I wish them the best of luck coming up with something that people are going to want. So what's the current status of marijuana in Alabama? The law's on the books. Medical marijuana is legal. Can people and patients go out there? Can doctors recommend it? Is it in use? No. It's going to be a year or 2 before all of the deadlines and bureaucracy and red tape is in place before doctors can begin recommending medical marijuana. A couple months after the law was passed, the governor and the Speaker of the House and Alabama Senate established a 14-member cannabis commission. And the Cannabis Commission is made up of mainly physicians and pharmacists and farmers. The Cannabis Commission cannot begin accepting applications for licenses to grow or distribute medical marijuana until September 1 of 2022. So almost a year from now. Once the State Cannabis Commission gets the applications, they have 60 days to either approve or deny. So what that means is it will be October 31st at the earliest before medical marijuana or anybody will be licensed to grow or distribute medical marijuana. Now, another requirement of the law is that the Cannabis Commission has to set up the Alabama Medical Cannabis Patient Registry System. And what that will do is it will electronically track physicians' certifications of medical marijuana. It will track patients that are recommended to use medical marijuana. It will keep up with daily dosage recommendations, and it will keep up with all medical treatment that medical marijuana is used for. Given the deadlines that are so far out in the future and the expected bureaucracy and red tape, I think it will be maybe beginning to middle of 2023 before medical marijuana is actually out there and in use. So we've talked about the new law. What is the effect on the Alabama Work Comp Act or work comp claims? And the answer is very little. And there, in fact, are no negative, there will be no negative impact on workers' compensation based on what is in the law. The law, the recent cannabis law does not put any more responsibility on employers, and it does nothing to protect employees. The law clearly states, the new law clearly states that it does not affect an employer's right to deny or present legal defenses to a claim that an injured worker was impaired by medical marijuana and that impairment caused their injury. So it doesn't change anything as far as the Workers' Compensation Act. I think there will be there'll be three primary issues which I will address here in a moment with regard to medical marijuana and its impact on work comp claims. The first will be, can or will employers be responsible for accepting as compensable claims where employees are injured and their injury was caused by medical marijuana impairment? And we just talked about that. The law says it does not affect the employer's ability to use that as a defense. I think the second big issue will be whether medical marijuana treatment is a reasonable and necessary treatment for an on-the-job injury. And finally, if medical marijuana is a reasonable and necessary expense, does the employer or the work comp carrier have to pay its cost? Now let's look at the defense under the Alabama Work Comp Act for employees that are under the influence of alcohol or impaired by marijuana. 25-551 of the Alabama Comp Act says that no compensation, and that's important, I'm going to come back to that in a minute, but compensation, no compensation for an injury or death caused by an accident due to the intoxication of an employee that is under the influence of alcohol or is impaired by illegal drugs. Now that's what the Comp Act says, illegal drugs. Now the Comp Act that we have now has been in place since 1992. Back then it certainly didn't envision legal drugs. But think about it, alcohol, it mentions alcohol, it doesn't say illegal alcohol or legal alcohol, there is illegal alcohol. The new cannabis law is not going to affect, as it says in the law, the employer's right to deny compensation for a claim that is caused by an employee's impairment to marijuana, be it legal or otherwise. Now, I said compensation earlier, and that's because it doesn't affect medical benefits. If an employee is injured, they're impaired by drugs or alcohol, they're not entitled to compensation, indemnity benefits, permanent partial disability benefits. They still are entitled to medical treatment for life reasonable and necessary medical treatment for life for that injury for which they could receive no compensation. Now, proving that an employee is under the influence of alcohol is basically easy. There's blood tests and urine tests, and alcohol metabolizes out of the body a lot quicker than marijuana. So it's easy to determine if somebody is under the influence of alcohol just by the way they smell or what their blood alcohol test says. That's not true for marijuana. Marijuana metabolizes out of the body a lot slower than alcohol. In fact, it can be in a person's system for up to 30 days, which means an employee that gets hurt and tests positive for marijuana may not have actually been under the influence of marijuana at the time. But the law says that an employee that takes a drug test, a DOT drug test, and comes up positive for drugs, they're conclusively presumed to be impaired. Now, what does that mean? That means as a matter of law, they're impaired by illegal drugs or legal drugs. They can't come to court and say, well, I didn't smoke it, I didn't inhale, I was with a bunch of friends and they were smoking it. Doesn't matter. They are impaired as a matter of law. It's up to the employee. The employer then has the burden of proving that that employee's impairment caused their injury. And because there is no test currently to determine the amount of marijuana in a person's system, or more accurately, whether they are currently impaired at the time of their accident by marijuana, it puts a harder burden on the employee. And the methods of proof that an employer has in defending a claim like that is to put on eyewitness testimony from co-employees, from supervisors, to say that the person, say if it's true, that the person was slurring their words, or they were falling, or their eyes looked red, and things like that. So that's pretty tough to prove. One thing that some employers have, and I highly recommend it, is a reasonable suspicion form. And I have one. If anybody would like one, just email me and I'll be happy to send it to you. But these reasonable suspicion forms, it's about a 4 or 5 page document, and it's filled out right then and there. It might even be, and supervisor may start filling it out before the accident, but it's filled out basically in real time. And it has a request detailed information about names, witnesses, places, and then it has a lot of boxes to check regarding what that supervisor or employee sees that raises a reasonable suspicion that the employee was under the influence of illegal drugs at the time of their injury, and that caused their accident. That form is extremely helpful, because without that form, when we go to trial to try and prove the impairment caused the injury, we have to rely on witnesses to come forward, like supervisors and employees. And it might be a year or two after the accident. And a good plaintiff lawyer on cross-examination is going to be able to discredit those people by saying, you remember all this in detail a year or two later, and why didn't you write it down? Why didn't you report it? And things of that nature. With a reasonable suspicion form, that's gone. I mean, it's filled out in real time, and there is so much information to fill in, it leaves little doubt, depending on, of course, what the information is. But if it proves, or if it tends to show impairment, that is great evidence that I think will win work comp cases where we're denying compensation because the employee was impaired and that caused their injury. Now, in thinking about that and the legal status of marijuana in Alabama, I got to thinking of a potential ironic situation we'll probably see in the future. We may have a case in the future where an employee went to trial, the judge said they were impaired and that caused their injury, so they got no compensation benefits because they tested positive for marijuana. And it doesn't matter if it's legal or illegal, but they get lifetime medical. Well, down the road a few years, some doctor is going to recommend that medical marijuana is a reasonable and necessary medical treatment for their injury. So they get fired from marijuana, but then they get treated with it. Somebody will get that. Now, other states that have legalized marijuana have grappled with a couple of issues, and that is whether it is a reasonable and necessary medical treatment in work comp, and if it is the employer or the insurance carrier responsible for paying? Now, Alabama's new law does not address the question of reasonable and necessary, unfortunately. Under the Work Comp Act, the generic definition of reasonable and necessary is basically any reasonable treatment recommended by the authorized treating physician. So it's an open question still in Alabama whether medical marijuana will be a reasonable and necessary expense. But what does the new law say about work comp, or what doesn't it say that's applicable to work comp? The law doesn't ban work comp or doesn't ban marijuana in work comp cases. And the legislature certainly could have done that. I said the law makes clear that the employer does not have to pay the cost of medical marijuana under any circumstances. So it's going to be up to, going forward, it's going to be up to our courts to decide if medical treatment is reasonable and necessary. And that will probably be on a case-by-case basis. And I expect there will be a great deal of litigation, at least early on, depending on whether doctors say, or if judges agree with doctors who say it is a reasonable and necessary treatment. So what is the new, we've talked about what the new law's effect on work comp. What is the new law's effect on employers? And the answer again is very little. And the answer again is nothing negative. The new law imposes no new obligations on employers. In fact, the Compassion Act goes out of its way to be pro-employer as possible. Now, the new law makes it clear that it is up to the employer and not the state to decide if and how it will discipline, monitor, allow its employees who use medical marijuana. Employers can keep the same policies in place that they had before the law was passed. They're not required to change those for any reason. In fact, they can update their policies to include testing for medical marijuana and provisions that tell their employees that a positive drug test for marijuana, legal or illegal, will lead to your termination. Employers are still allowed to have drug-free workplace policies, which is important because it lowers their insurance premiums. Employers do not have to hire someone who has a medical cannabis card, even if they're not impaired. An employer can just decide, you've got a medical cannabis card, I'm not hiring you. In fact, the employers can create brand new policies that take legalized marijuana into account. They can terminate employees that test positive, even if the employee has a valid cannabis card. And employees that have cannabis cards have no legal rights under the law to request or require their employers to accommodate them because they're taking legal marijuana. Employers can even adopt a new policy that requires their employees to notify them if they obtain a medical cannabis card. And if they do, the employer can then turn around and fire them. And there's nothing the employee can do about it. In fact, in a situation where an employee loses their job because they tested positive for legal marijuana, if they take a drug test and they're fired for that reason, or if they refuse to take a drug test, under the Compassion Act, that employee is considered to be terminated for misconduct. And what does that mean? That means they're fired for cause. And because they're fired for cause, they are not entitled to unemployment compensation benefits. So you see that the Compassion Act is very employer friendly and not employee friendly. And that might, the title Compassion Act may apply to employers more to employees. How does Alabama's new legal medical marijuana law interact with federal law? Well, as I said earlier, we have the Department of Transportation regulations, so that employers here that have just regular employees, labor force, and that type of thing, they don't have to test for marijuana if they don't want to. But they're still required under DOT guidelines to test anybody they employ in safety sensitive jobs, like truck drivers, like operators of heavy equipment, and that type of thing. Every year, as more and more states legalize marijuana, the DOT puts out something that says we want to keep stressing that the fact that states are legalizing marijuana has absolutely no impact on the requirements of the DOT regulations, and that employers drug test employees that are in safety sensitive jobs. So how do employers treat the new medical marijuana law? What are they going to do differently? Nothing. They should treat it the same as they did alcohol and illegal drugs, because there are no repercussions whatsoever for disciplining, terminating, not hiring people that have a legal cannabis card and use medical marijuana for a legitimate reason. Now, medical marijuana can be a good or a bad thing with regard to the Work Comp Act. There's several potential benefits or pros, and there are quite a few cons. As all of you know, I'm just going to talk about the pros first. This country is under the midst of an opioid crisis because of years and years of overprescribing of opioids. Opioids are the leading cause of death in lethal drug overdose cases. In fact, 115 people a day on average die from opioid overdose. Now, there have been many studies that show a positive correlation between states that have legalized marijuana and a reduction in opioid deaths. That's averaged about 25%. According to the Journal of the American Medical Association, states with legalized marijuana saw opioid prescriptions on a daily basis drop by 2.21 million. And Medicaid has seen a drop in opioid costs of almost 6%. Now, we know in work comp cases that injured employees, the most often prescribed medication is opioids. And that has some negative repercussions on work comp claims. Injured workers on opioids are typically off work 3 times longer than injured workers that have non-opioid therapy. And injured workers on long-term opioid therapy average a year off work, whereas people on non-opioid therapy have a lot shorter time that they're out of work. So let's talk about, well, let me go back. So the question is, when we're talking about the pros, is can medical marijuana be as effective as opioids in successfully treating chronic pain? Let's talk about some of the negatives of using marijuana as a medical treatment in work comp cases. Marijuana has a negative impact on user actions. It produces impaired motor skills, coordination, balance, inconsistent work effort, absenteeism, lowered productivity, needless risk-taking, and even dangerous actions that risk hurting that employee or others and leading to an increase in on-the-job injuries. So in light of everything we've talked about, what is the future of medical marijuana in this state and in the country? Well, with developments rapidly happening over the years in marijuana legalization, it's affecting more and more aspects of all of our daily lives. And as we just discussed, medical marijuana, legalized marijuana, can have both positive and negative impacts, especially in the work comp field. Now, the dilemma that employers have and insurers is, what is the best way, the most productive way to treat an employee after they're injured on the job to get them back to work. And whether medical marijuana is the best treatment is still an open question. And that is because of its status under federal law as an illegal Schedule I drug. Because the FDA is not involved and because doctors across the country are fearful of trying to conduct any studies on the effectiveness of marijuana, it's still an open question whether it is a good treatment that could replace opioids. The research that needs to be done includes what are the long-term effects of medical marijuana? Is it a viable option for opioids? What is the proper dosage to effectively treat somebody that has chronic pain from an on-the-job injury? And importantly, this research will help develop a test to determine a person's impairment by marijuana at the time of their injury. And none of this can happen until the federal government either legalizes or deschedules marijuana. And I don't, as I said earlier, I don't see them legalizing it. I think there's a good chance that at some point they will lower it to a Schedule II drug, and that will open the door for this research that's so necessary that we all need to know so we can make a decision whether medical marijuana is in fact a better treatment than opioids for on-the-job injuries. And by descheduling or legalizing marijuana, that will also allow FDA oversight, which is very important. Now, as I said earlier, the federal government in the last few years has moved a little when they passed the Farm Bill in 2018 and legalized industrial hemp. Before that, it was illegal because it was part of the cannabis plant. The FDA has approved 4 drugs that contain CBD, 3 drugs that contain CBD and 1 that contains THC. And the most effective one that I've read about is Epidiolex, which is a high dose CBD drug that is used to treat people that have severe seizure conditions. But the impact of legalized marijuana is still evolving. And in this state, we won't even see it until probably 2023. But as I said, whether it's legal or not, it's not going to affect work comp claims. The question that needs to be answered at some point is it a reasonable and necessary medical treatment? Now, the new law that Alabama passed addresses some of the concerns that employers have when the law came out. We know because the law says the employers and the insurers are not going to be responsible for paying for that treatment. Of course, employees cannot use medical marijuana on the job, just like they can't drink on the job. The big question, though, as I said, that needs to be answered is whether it is a reasonable and necessary medical treatment. Now, I wanted to talk briefly. Let me ask first, does anybody have any questions or anything they want to share? Okay. Yes, ma'am.
Does the decrease in opioid prescriptions in states with where Canada or where THC is allowed, does it directly correlate to an increase in THC prescriptions?
No, I didn't. What the lady asked was whether with states with legalized marijuana and have decreased opioids, do they see an increase in THC prescriptions? Is that? Yes. Yeah, the study I read did not address that, and that's a very good question. The percentage was states with legalized marijuana has seen a 25% drop in opioid prescriptions. Now, what the study did not address that I saw was whether medical marijuana prescriptions, it wouldn't technically be a prescription, but whether that went up and whether those were recommended more. And the reason that might not have been in there is because it's some of these states, it's probably hard to track when marijuana is recommended, especially in states that allow recreational marijuana because you can just go into a store and buy it. You don't need a doctor's recommendation. But that's a good question. Anybody else? I thought I said, yes, sir.
Submitted to the legislature the next session to repeal that law.
To repeal the medical marijuana, the Compassion Act that was just passed? I do not. Now, do you? There is one? There are, okay. There are currently, the gentleman asked me a question, there are currently 2 proposed bills in the legislature, the Alabama legislature, to repeal the Compassion Act. Is that correct? What do you know what the reasoning is? Constitution. Too many loopholes. Well, and that, that takes me back to Mississippi. I think a similar thing happened where Mississippi passed a medical marijuana law and the courts overturned it as unconstitutional. Now, I don't know if that was the reasons, and maybe you do. I don't know. But, well, that's interesting to know. I should have read what you read last night and I would be more informed, but I appreciate knowing. And okay. Well, what's good is if I'm asked to come back next year, we'll have even more to talk about. Anybody else have a question or a comment? All right, I wanted to just briefly talk about 2 work comp cases in Alabama where an employee was impaired by marijuana. Now, these are older cases. Obviously, they didn't come out after the new Medical Marijuana Act because that just came out in May of this year. But they're still illustrative and they still apply because, as I said, whether marijuana is legal or illegal is irrelevant to the defense the employer has that no compensation is owed if an employee is impaired and that impairment causes their on-the-job injury. Now, the first case was a 1998 case in Montgomery. And in that case, the employee was monitoring a pan stacker. And some of the pans became jammed. So he climbed up the machine somehow. And he was able to release the jam. And he continued to watch the pans from his perch on top of the machine. And at some point, he was wearing a baking mitten and it got caught in a chain sprocket and sucked his fingers in. And it luckily only amputated one and hurt a couple of others. But he went to the hospital and had a DOT drug test, which was positive for marijuana. So the employer or the carrier denied compensability. And that case went to trial at the state court level. Now, before trial, the plaintiff and defendant stipulated that the test was proper under DOT guidelines, and the employee tested positive for marijuana. So the only issue in that trial was, can the employer prove that the impairment caused the injury? Well, at trial, a supervisor came and testified, but he testified for the employee. He had seen the employee that day. He had talked to the employee that day. He didn't notice anything out of character. He wasn't having problems doing his job. He had no outward signs of being under the influence of medical marijuana or any other drug or alcohol. There was no evidence presented, and the supervisor testified that the injured worker was not acting erratically or lethargically. So what the trial court held in that case was that the employee didn't meet their burden of proving that the employee's intoxication or impairment rather by marijuana caused his injury. And the employer appealed, and it went up to the Alabama Court of Civil Appeals, who affirmed the trial court's holding that there was substantial evidence showing the employee was injured, but not showing that medical marijuana impairment caused that injury. In fact, the injury was primarily caused, so the court held, because there was not a guard on that sprocket where the person was injured. Just one more case that has kind of a different outcome. This was in 2001. An employee worked for a sign company. He was moving a big Kmart sign that was on a couple of dollies. And company policy said that a sign of that size requires at least 2 workers to use it or to move it. So the worker proceeds to move it on his own. It hits him in the shoulder, knocks him down, and the sign falls on it. Now, luckily, he's not killed, but he hurt his shoulder. So he goes to the hospital, has a drug test, and it comes back positive for marijuana. So the employer denied compensability and the case went to trial. In that case, the trial judge ruled for the employee. And what was interesting about the trial judge's ruling was it said the employee was impaired by marijuana, but it wasn't the only reason he was hurt. It was just one cause. There were other causes that contributed to his on-the-job injury. So that got appealed, and the appellate court found for the employer. And what the appellate court said was, if a person is impaired by marijuana or drugs or alcohol, and that leads in any way to an injury, it doesn't matter if there are other causes. If being impaired is one of the causes, the others don't matter. And that employee is not entitled to compensation benefits. They get medical benefits, as I said earlier. Does anybody have any other questions or comments? Okay, we just want to talk about one other area. We've seen over the last couple of years that America is in the midst of an employment crisis. Because of COVID, for one thing, COVID has changed how, when and where people work. And also because of historically low unemployment rates, employees are more and more jumping jobs and taking different jobs or even resigning, especially when COVID was in effect. When in Alabama, COVID's been in effect, but when Alabama allowed additional unemployment compensation, it was cheaper for the employees in some cases just stay off work. So there's been a crisis with employers trying to find qualified workers, especially in the labor field. And one way that employers are starting to get around that is either by not drug testing potential candidates or removing marijuana as one of the tests in the drug screen before the employee is ultimately hired. And that has led, of course, to concern amongst insurers and employers that there will be a sharp increase in on-the-job injuries because there is not testing like there had been in the past for employment. You had to pass a drug test. So in August of 2021, 4.3 million Americans just up and resigned from their jobs. Amazon, and this is an interesting one because we have Amazon, we have a facility here, and I think another one's being built. Amazon earlier this year said it was going to stop pre-employment testing for marijuana. And in fact, Amazon also said that it backed the legalization of marijuana on the federal level. Now, Amazon will still treat on-the-job injuries the same and conduct drug tests to see if the employee is impaired. And jobs at Amazon that are covered or regulated by the Department of Transportation, like truck drivers and pilots and those types of things, Amazon still has to drug test them pre-employment, just like they always had to, because the DOT regulations trump state laws legalizing marijuana. Anybody have any questions or comments?
What about the delivery drivers for Amazon?
Yes, they are. Anybody, and I should have said this, anybody that has to hold a commercial driver's license has to be tested. So yes. Anyone else? It's been a pleasure speaking to everybody today. I hope everyone here and online had a fun and an instructive 2021 AWCO conference. And I look forward to seeing you next year, and maybe the law will be overturned, which will give me even more to talk about, and I can wear this tie again.